public session. The purpose of this morning's meeting is to meet with the Minister for Justice and Equality, Deputy Charles Flanagan, and his officials for a briefing and discussion on the withdrawal of the United Kingdom from the European Union Consequential Provisions Bill 2019 and related matters. I want to welcome the Minister for Justice and Equality, Deputy Charles Flanagan, and his officials. But before we begin, I must caution members should be aware that under the salient rulings of the Chair, members should not comment on, criticise or make charges against a person outside the House or an official by name in such a way as to make him or her identifiable. And if I can also indicate to members and the guests accompanying the Minister that all mobile phones should be put on silent, please. So I now invite the Minister to make his opening statement.
Thank you, Caoimhghín, and thank you for the invitation to appear before you this morning and for the opportunity to brief on the current legislation that I see and members will see on the screen in front of them. I'm joined this morning by officials Jimmy Martin, Assistant Secretary, Yvonne White, Brian Merriman, William Dwyer, Regina Terry and Eileen Devoy. Thank you. Can I say that the Government remains firmly of the view that the best and only way to ensure an orderly withdrawal on the part of the UK from the European Union is to ratify the withdrawal agreement. Having said that, in view of the ongoing uncertainty in the United Kingdom, I and my department have been advancing in an intensive way our preparations and planning for every scenario, but in particular, having regard to our discussion this morning, preparing for a no-deal scenario or a worst-case scenario. If the UK becomes a third country on the 29th of March, without having ratified the withdrawal agreement with the European Union, then a very wide range of EU rules in relation to justice and security will no longer apply to or in the United Kingdom. On the other hand, should the withdrawal agreement be ratified before the 29th of March, many of the preparations and contingency measures that I am about to detail will not be required, at least in the short term. So the purpose of the legislation now before the House is to offset some of the damage which may arise if the UK depart without a deal being in place. While there are a number of Brexit implications for the justice sector, key risks have been identified in two areas, namely extradition and immigration. These two areas require primary legislation to be in place and are set out in parts 13 and 14 of the bill before us. Looking in the first instance to Part 13, the bill provides for two amendments to the Extradition Act 1965. One of the key issues identified by the Department of Justice and Equality is to ensure that effective extradition arrangements are maintained between Ireland and the UK. In the event of a no-deal Brexit, the provisions of the European Arrest Warrant would no longer apply to the United Kingdom, and at 11 p.m. on the 29th of March, persons detained on foot of European arrest warrants would be released. It's critical, therefore, that extradition provisions are in place immediately following the UK's exit from the European Union. The optimal solution identified by my department is to apply the 1957 Council of Europe Convention on Extradition, to which both Ireland and the UK are party to extradition arrangements between Ireland and the UK. The provisions of the Convention are given effect to by Part 2 of the 1965 Extradition Act. While the extradition procedure under the Convention is not as effective or as efficient as that of the European Arrest Warrant, in the event of a no-deal Brexit, it would provide a workable solution. The intention would then be to legislate for and move to an extradition arrangement with the UK similar to that which obtains in the matter of the European Arrest Warrant. However, the 1965 Act does not permit extradition of own nationals unless the relevant extradition provisions otherwise provide. Transmission of extradition requests is via the diplomatic channel and in hard copy. So the Office of the Attorney-General has advised that clear provision should be made in Section 14 of the bill of the 65 Act, providing that the ban on extradition of own citizens should not apply in reciprocal circumstances where the requesting states also extradite own citizens. So the amendment to Section 14 in respect of Irish citizens acknowledges the need to amend Section 14 of the 65 Act in order to ensure that the current European arrest warrant arrangement in relation to extradition of own citizens continues, and that in applying the provisions of the Council of Europe Convention, extradition of an Irish citizen will be permitted on the basis of reciprocity, where the law of the requesting country does not prohibit the surrender of its citizens. In this regard, it should be noted that the United Kingdom has already indicated that it intends to continue to extradite its citizens post-Brexit. The second amendment is in relation to Section 23 on the matter of request for extradition. The Act in this regard is being amended to alleviate the burdensome extradition procedure with respect to requests to the Minister for Justice via the diplomatic channel in hard copy. In this regard, the amendment to Section 23 provides for direct transmission of extradition requests to the Minister for Justice and Equality rather than via the diplomatic channel, and for the transmission of such requests by more modern means of communication, that is, by electronic means or otherwise. The amendment gives the Minister for Foreign Affairs and Trade an order-making power, following consultation with the Minister for Justice and Equality, to provide for requests for extradition to be made directly to the Minister for Justice, where this has been arranged with a country by direct agreement. If I can't go here, I now turn to Part 14 of the bill, which contains a number of amendments to the Immigration Acts. Section 88 and Section 89. The amendments in these sections of the bill are for the purposes of correcting a lacuna in the provisions relating to the non-refoulement in our law. I should point out that refoulement considerations were in fact being undertaken at all times. This provision provides legal certainty in this area. The amendment is required as failure to introduce this amendment would expose us to the risk that removal would be unsuccessful and would therefore undermine arrangements to operate a Dublin regulation-style arrangement if needed. Section 90 of the bill amends the 2004 Immigration Act to provide a legal basis for fingerprinting Irish visa and transit visa applicants. The taking and sharing of biometrics is key to the operation of the British-Irish visa scheme, which enables a short-stay visa issued by Ireland in respect of certain countries, currently India and China, to be used, and also travel to the United Kingdom without the need for a separate visa. This requires biometric data to be captured and checked against both Irish and UK systems. The continuance of this scheme is considered to be very important by both the tourism and the business sectors. In addition to the above amendments, there are some pieces of secondary legislation required to be in place by the 29th of March. These will cover issues such as facilitating the recognition of UK solicitors' qualifications in the state and, in the context of asylum seekers, designating the UK as a safe third country. There are other important issues that my department continues to address and to prepare for. However, I believe the two I've covered today are the most pressing. So I wish to thank members for your attention. I am happy to respond to any questions, observations or submissions that members might have. Thanks, Caoimhghín.
I note Deputy Donnacha O'Leary has indicated. Deputy Jim O'Callaghan, Deputy Jack Chambers. Are there any others who would like to indicate just at this point? Okay, we'll open it up. Deputy O'Leary, please.
Thanks, Chair. I thank the Minister for making himself available. I think it's a useful engagement in the context of, I suppose, what is going to dominate these houses for the next couple of weeks. I have a few questions about what's in the bill and a few questions about what's not in the bill. So I'll start with what's in the bill. First, you finished on it really, I think, on the non-refoulement, and just to clarify, in relation to section 88 and the new section 3B to the Immigration Act 99, it appears to clarify that these provisions will apply to the period commencing on 31st December 2016. Now, my understanding is that this whole area is seeking to clarify an area that was struck down by High Court case in 2018, SG Albany versus the Minister for Justice. So I suppose I'm trying to understand the time frame and how it can be that if the case that saw the previous section struck down or rendered inoperable was in 2018, how for the period between December 2016 and I suppose this piece of legislation, how we can confidently say that that section applies.
Well, the Part 14 of the bill deals with the amendments to the Immigration Acts, and that in effect deals with a lacuna in the provisions relating to non-refoulement. The important aspect here is that sections 88 and 89 amend not only the Immigration Act of 1999 but the Immigration Act of 2003. That will have the effect of confirming that immigration officers, in considering removing or deporting a person from the state, will, in line with international obligations, have the power to undertake the refoulement consideration. Section 88 also includes a provision confirming that where, in making an order of deportation since the 31st of December 16, consideration was actually given to non-refoulement, and the practice will continue. What we're doing in the amendment is providing a legislative basis to the consideration of refoulement matters. This is in line with Section 50 of the 2015 International Protection Act for all non-nationals being removed from the state. So the amendment will have the effect of restoring references to non-refoulement in the Immigration Acts, and that has remained both the policy and the practice to apply refoulement principles to all removals from the state, and that should cover the point that has been raised by the Deputy.
I suppose I'm not quite clear. Like, my understanding, I haven't read the full judgment, but my understanding is that the 2018 judgment found a difficulty with Ireland's processes in relation to non-refoulement considerations, right? Is it the case that even though, like, I mean, I find it hard to understand that how this legislation is saying that we're satisfied that non-refoulement considerations were undertaken and that deportations from December 2016 up until the court case, that they're considered to have been valid, even though the court decision hadn't been handed down. So, like, I mean, is it the case that in practice, even if there wasn't a legislative basis for it subsequently, non-refoulement considerations were given, therefore, that even though the legislative basis didn't exist, that procedurally all the people who got deportation orders did in fact get this consideration, so therefore they are covered, they were valid deportations. Am I understanding that right?
Yeah. On the basis of the technical nature of the question, could I ask an official maybe to respond? Yeah. Right.
Thanks, Chair. Yeah, the relevant court case, as you say, was a SG, and the difficulty that arose was that when the International Protection Act was implemented in 2015, it inadvertently it repealed the Refugee Act 1996, which in Section 5 had a provision on refoulement that applied not only to protection applications but also to all removals from the state, whether they be protection related or not. When the 2015 Act was implemented, it repealed the 1996 Act and inadvertently disapplied non-refoulement considerations to non-protection applicant removal, so to deportation orders for general immigration cases. But the practice remained that, and it only came to light in the High Court case, but the practice was always that non-refoulement considerations were considered in every case, every removal case from the state. What we're doing here is to restore the position whereby there's a legal basis to the non-refoulement consideration for non-protection related cases that are dealt with under the 1999 Act and the 2003 Immigration Act. And the section in 3B is to sort of give a retrospective legal basis, if you like, to deportations that would have taken place from 31st of December until the bill is enacted. But it's only where the actual non-refoulement consideration has taken place. So, if a deportation order is the subject of a, say, court proceedings, something like that, that provision, that retrospective provision, doesn't impact on that.
Okay. All right. Thanks. Thank you for that. Yeah. Thanks. Sorry, no, that was a bit fussy, probably, but it's worth asking all the same. I suppose worth asking just in relation to both that section and in relation to extradition, and I suppose in relation to legislation generally speaking. I suppose currently it is the case that obviously Britain is a signatory to the European Convention on Human Rights. Now, significant and influential elements of the Conservative Party have indicated a desire to renounce the European Convention on Human Rights. Would it be the Minister's position and the Department's position that this legislation would need review and revision potentially if Britain did depart the European Convention on Human Rights? Yes.
Yeah. We're dealing here, Caoimhghín, as I said at the outset, with what might be described as the worst case scenario in the event of there being a no deal or a crash out. Obviously, we need to ensure that arrangements are such that any adverse consequences will be mitigated. And yes, in the event of there being developments in the UK, with particular reference to the future relationship arrangements, then it's expected that over the course of time arrangements would be made along the lines of those which currently exist. And any new legislation will be reviewed against the background of any developments in the UK.
One final question on what's in the bill before I move to what's not in the bill. The section on fingerprints, which is section... sorry. I'm sure you're familiar with it anyway. Sorry, the section 90 wasn't in the heads of bill. My understanding from what the Minister's outlined that this applies to only one or two countries. I think India is one, and perhaps China, I think was the other.
China, India.
China and India, very well. I suppose one, it wasn't in the heads, but two, the taking of fingerprints seems perhaps somewhat overbearing. Is this a common feature of visa applications of these natures, and is it strictly necessary? Like, I mean, obviously, everyone wants this programme to continue if it's of value to the Irish economy, if it's of value to the individuals involved, but is it strictly speaking necessary? And is it, like, I mean, I would question if these were European countries whether taking of fingerprints in this manner would be compliant with the GDPR. Obviously, these aren't, not being European citizens, perhaps the GDPR doesn't apply to them, but it does. I would ask the question whether it's strictly necessary to have this fingerprint provision in.
Yeah, well, it's a key aspect of the of current operation of the British-Irish visa scheme, which enables short stay in Ireland by persons who also travel to the UK without the need for a separate visa. Now, there is a requirement that the biometric data be captured and be checked against both the Irish system and the UK. I believe it's very important that that would be continued. We must acknowledge, of course, that we are not members of Schengen, although we are engaged in Schengen information systems. But it's important that the concerns on the matter of sharing the fingerprint data with the UK does provide an element of legal certainty, and it's important, therefore, that that continues, and it will be in compliant with human rights legislation. I might answer the earlier question to confirm that the British have already indicated that they will continue to participate in the European Convention after Brexit.
I'll just move on to what's, I suppose, not in the bill, and I suppose just as a first question that I won't detain the chair too much or the committee too much longer, but just in relation to, I suppose, the process behind the preparation of this legislation. Did the Minister engage with, first, the Gardaí, two, with the DPP, and three, even with the PSNI, and ask what they felt were the outstanding needs in relation to this legislation? And were there any asks from those three agencies or any other relevant justice agencies that the Minister was not in a position to accommodate in this legislation, and is it being dealt with by other means?
Yeah, we have ongoing contact with all of the offices mentioned by the Deputy, but with particular reference to the preparation of this legislation, yes, there was specific contact, and also with the Home Office and with appropriate UK offices in order to ensure that we were in a position to formulate a schedule of laws and amendments and a regime that would mitigate against any adverse consequences. But remembering all this is against the background of a contingency to prepare for a worst-case scenario.
Yes, okay, well, I appreciate that, but I suppose there was a second part to that question is, were there specific asks from those agencies in relation to this legislation that either you said, no, we can't do that, or yes, we can do that, but not here, we'll do it in another way?
There was a lot of discussion because that's exchange, but we don't need primary legislation.
I'd ask Jimmy Martin to deal with that, who was involved in the detail of the discussions with parties both within the jurisdiction and in the UK.
Please proceed.
Yes, Deputy. It was a very extensive progress. The first thing we did is we went through every single EU instrument in the Justice and Home Affairs, and that was 700 different instruments to see how they'd be affected. And then we also had a series of meetings with both the Garda Síochána, the Director of Public Prosecutions, the Court Service, the prison service and the probation service to see how they'd be affected. We also separately had contact with the Commission and their recommendations as what issues need to be addressed, and as well we've had contact from the Home Office about what issues they need to be addressed. So what's in the legislation is what requires primary legislation. There are a number of different areas which don't require primary legislation. One of the biggest asks of the Gardaí was in particular in context of their communications and data exchange with the Police Service of Northern Ireland. They exchange about 60,000 to 70,000 pieces of information every year with UK law enforcement agencies, and in particular the PSNI. And one of the effects of Brexit will be that the UK will become a third country for the purpose of data protection. So there was a big concern that we had to look at the data protection implications for exchange of information with that. So in consultation with those services and the Attorney General's Office, we were looking at how this can be done in the context of the Law Enforcement Directive on Data Protection. And we have been consulting both with the Gardaí, the AGs, the DPPs and the other services about that. And that can be done within the context of the EU instruments. It doesn't require primary legislation, but that's one aspect of things. But the list of things that has to be done, as you'll understand, if it affects so many different areas, is quite long and could take us the whole day to get through them all. But there are huge areas. What we've tried to focus on is the ones which have the most substantive effects and the most instantaneous, and they would be extradition and the common travel area. They're the areas. And data exchange, both for the purposes of police to police, but also for the purposes of running the common travel area. They're the biggest areas and they're the most substantive areas. But in all those, as I said, we've taken into account all the services involved, and we know the UK and the PSNI have set out what they regard as their priorities, and we're able to match them. And also the Commission have set out what areas Member States should have as a priority for contingency preparedness. So all the work involves all these different areas come together. But as I said, having gone through the exercise, there's only 2 areas that required primary legislation. I should say there are certain things we just cannot do, like the big ask, for example, of the UK in the police cooperation area was continued access to the Europol information system and the Schengen information system, but they're European IT things, and it's a matter for Europe to decide that. We can't decide that. So there are certain areas that are outside our competence, but within our own competence they're being addressed. I said 2 in the context of this legislation, but there will be secondary legislation, and then there are a whole load of administrative arrangements being made to cover all these areas.
I suppose on that, right, a supplementary to that first, I don't a bit envy any of the officials that had to go through the hundreds of European instruments. I'm sure that was a very arduous task. I want to ask about one specific element, but otherwise, if it's possible subsequent to this meeting, if a summary or some form of document can be provided to the committee outlining what the major changes to secondary legislation are, what are the significant changes and what implications they will have. Obviously, it's a matter for the Minister, but it's a matter of useful information for us. The specific one I want to raise is the issue of bail, whether there are significant secondary changes required to ensure that cooperation in the area of bail, north, south, east, west, continues. And whether that requires any significant changes or whether that's something that continues as a matter of course.
We can provide that to the committee at a very early date in terms of the list of the statutory instruments that will form the programme of secondary legislation, with a note in respect of each. I don't envisage any changes with the UK or indeed with Northern Ireland on the matter of bail arrangements.
And sorry, I suppose not so much that there be any changes, but that any changes be required to secondary legislation to ensure that it doesn't change. Is that your understanding?
Not to my knowledge.
Okay, thank you. I have two final questions.
Want to just underscore what the Deputy has said by acknowledging the close relationship between the Garda Síochána here and the PSNI, and it's anticipated that that will continue irrespective of the deal or no deal scenario.
Okay, very well. Thank you, Minister. Two more questions. Yeah.
Final questions.
Sure. There was two heads, 16 and 17, relating to data and information, mostly in connection to immigration, the GDPR, that are no longer in this, did not make it into the final bill. Can it be dealt with in secondary legislation, or how is it the case that it is not required any longer?
Yeah. In the initial stages, it was envisaged in the course of consideration that we would need primary legislation to cover the areas as referred. As it happens, following further consideration that the only issue requiring primary legislative consideration was in the area of fingerprinting. The other sharing of information in terms of the data sharing is covered under secondary legislation. And that's why the heads didn't proceed.
Minister, the final question I want to ask you follows on from a set of hearings we had a number of weeks ago. And I want to read to you just a brief passage from Mr Brian Gormley, the Committee on Administration and Justice, in relation to citizenship rights of citizens in the North. And I suppose this politically was a matter that was significantly discussed, but legally there is still very little certainty to it. I'm just going to read this quote. The citizenship issue is an example of how basic assumptions of the Good Friday Agreement have been undermined. It recognises the birthright of the people of Northern Ireland to hold Irish or British citizenship on the basis of equality. The basic breach of this principle of equality by Brexit would be that Irish citizens would remain EU citizens, whereas British citizens would not. It amounts to a new focus of division between the two main communities. It has also become clear that Brexit could make the status of Irish citizens living in Northern Ireland constitutionally and practically insecure. If Brexit goes ahead, Irish citizens will be EU citizens living in a non-member state. What rights do they have to live, work, access health and social services, and fully participate in the social and political life in the state where they are born? There are 7 possible answers to that question. The first possibility is that the Home Office will regard Irish citizens as really British, since UK nationality law decrees that most of those born in the UK have British citizenship. The second possibility is that the Common Travel Area will sort this out, but as the Human Rights Commission has suggested, Common Travel Area rights are based on sand. The third possibility is that under the withdrawal agreement, EU citizens living in the UK can retain many of their current rights by applying for settled status, and there was at one stage, I believe, a fee attached to that. So none of these options are appealing, as they involve the implication that those who choose Irish identity are in some way second-class citizens. Their rights as full participants in Northern Ireland life would depend on either denial of their Irish nationality. As yet unknown bilateral agreements between the UK and Ireland, both the Common Travel Area, are asking the Home Office to graciously allow them leave to live in the land of their birth. So I suppose there's very significant and weighty questions there, and we discussed them at length with Mr Gormley, with Mr Harvey, with several other witnesses. There is clearly a lack of legislative clarity for the basis for which Irish citizens, I suppose prior to any possibility of Brexit, perhaps there wasn't much dispute or issue into it apart from a number of areas. These areas of dispute is likely to increase significantly. So, Minister, I want to ask you, given the gravity of the implications of these changes, given the fact that the need for legislative clarity in Britain also, but also here in Ireland, to resolve this matter is very clear and has been outlined by numerous academics and speakers, why have we not sought to put some form of clear legislative basis for the rights of Irish citizens living in the North post-Brexit, particularly post a hard Brexit? Why have we not put in place some amendment to this legislation to affirm those rights?
Well, I want to say in the first instance, Caoimhghín, that the provisions of the Common Travel Area will continue irrespective of the type of arrangement that will follow the withdrawal of the UK from the European Union, and that includes a no-deal scenario. Both the British government and ourselves have confirmed that neither Irish citizens in the UK or British citizens in Ireland will be required to take any action to protect their status or rights associated with the current common travel regime. The issue that the Deputy is referring to surrounds the D'Souza case and citizenship rights. This is an issue that was the subject matter of discussions between myself and the Home Secretary in recent times. The British government are currently looking at whether or not they will proceed by way of legislative provision in order to clarify matters following that judgment. I'd be happy to keep the committee informed of the developments. There isn't certainty around it as yet, but all of the current arrangements that currently exist under the common travel arrangements will continue, and of course that involves the guarantees under the Good Friday Agreement.
Minister, I'd finish, but I suppose, as Mr Gormley said, common travel area rights are not to be on the end all. They're certainly not adequate for the needs of citizens in North. I've taken enough of the committee's time, but I'm sure some of my colleagues might follow up on this. But I'd also emphasise it's not just British legislation is needed. There is need for legislation. All the academics said in this jurisdiction to address this issue too. Thank you, Chair. Thank you, Minister.
Thank you, Deputy. Now, Deputy Jim O'Callaghan, please.
Thanks very much for coming in, Minister, and your officials. One of the great successes of EU membership has been the European arrest warrant, and I think one of the negative consequences of Brexit will be the fact that we won't have an EAW system in place between Ireland and the United Kingdom. I note what you said in your speech, Minister, that it's intended to operate the Council of Europe Convention on Extradition from 1957. I think that's a good idea. Obviously, that's dependent upon reciprocity between this country and the United Kingdom. We're in the process of introducing legislation here that permits extradition of citizens. Have they introduced already, have they enacted in the United Kingdom similar legislation permitting it, and do you think it will be in place by the 29th of March? And I don't mind who answers it.
Yes,
it's done. It's done in the UK,
yeah.
OK.
Yeah.
Under the EAW system, obviously the courts are involved here. If it's the case that somebody is going to be an Irish citizen is going to be extradited to the UK after Brexit or vice versa, to what extent will the Irish courts be involved in that? Will they have any involvement, or will it be a diplomatic process?
Yes, these are issues again that have been the subject matter of discussions with the Home Office. We have identified a number of issues. It's important to acknowledge that immediately after the withdrawal of the UK at 11 p.m. Irish time on the 29th of March, the UK will then submit requests under the Extradition Convention of 1957. That will involve a court process.
Okay. This may be a difficult example. If you have an individual who has an Irish passport, they live in, say, Antrim or Down, and they travel down to this country. They are Irish citizens because of their Irish passport, although they're not resident here. Would they be capable of being extradited under the European arrest warrant to other EU countries?
Yes.
Okay. Are they aware of that, or maybe they're not aware of it, but it is one of the consequences of their Irish nationality?
They're travelling in the state, and
they're a citizen.
Like anybody, they're also citizens, so they could be subject to an arrest, depending on the circumstances of the charge or whatever.
Just on the immigration issue, obviously the Dublin Convention requires that if you're applying for asylum, you have to apply in your first port of call. If somebody has applied for asylum in the United Kingdom and they're refused, or their process is still being considered, will they then be able to apply for asylum in this state again, or will we have some rules in place to say you've already applied in the UK?
Yeah, this, having regard to the fact that the UK, following the 29th of March, will not be an EU country, the Dublin Convention will be in issue, and we will have a bilateral agreement with the UK in order to ensure that the application cannot be made here as a consequence of a decision or otherwise in Britain.
Okay, and that will be in place by the 29th of March?
Yes.
And do the officials think that applications for asylum in Ireland will increase after the 29th of March if the British leave, because of the fact that applying in Ireland gives you an opportunity to, I suppose, have access to the full European Union? Or is that something that you're not
There's no evidence of that. However, it is something that we are giving consideration towards. And as I said earlier, our anxiety really is to mitigate any adverse consequence that might give rise to a large number of applications. Maybe I'd ask Brian to elaborate on that.
Thank you, Chair. The number of applications are actually increasing, but it's steady. We had about a 30% increase of applications last year. I think when one looks at the whole situation that's evolving in the United Kingdom, I'm not sure there's going to be a particular advantage to come here immediately, insofar as that they will have a lot of order to put on their new systems over there. Okay. So I'm not planning for a major difference, but there has been a steady upward curve.
Why do you think there was a 30% increase in applications last year?
There's no resettlement and relocation programme operating, for example, in Europe, which I think in the previous 2 years had made an impact, etc. But there still is, our main countries would actually be Georgia and Albania, for example, which are not in the EU, or indeed are acknowledged conflict zones. So at the moment, that's a continuing trend for the last year or so.
Just two areas which aren't dealt with, and you may not have any concerns about them, but one in respect of family law. At present, obviously, there's recognition of United Kingdom divorces. After the 29th of March, what's going to be the status in respect of the recognition of divorces in the UK, and indeed child abduction cases involving Ireland and the UK? At present, it's dealt with by, I think, Regulation 2201 of 2003. But do we have concerns as to how that is going to develop? And I did ask a PQ on that, and I got an answer on it, but...
Yeah, well, it's important to recognise that both Ireland and the UK are party to a number of international conventions negotiated under Hague. In particular, the 1980 Child Abduction Convention and the 1996 Protection of Children Convention. So we're satisfied, having regard to the content of those and those taken together, that these conventions will apply a framework that can be regarded as satisfactory in the circumstances, and that will be the basis of continued cooperation in that area. On the matter of the recognition of divorces, members will be aware that the recognition in Ireland of divorces granted in the UK is governed by the EU. If that EU regulation fails to apply, well, then we would fall back on the older 86 Act, the recognition of Foreign Divorces Act.
Okay. And just
I might mention actually that in the forthcoming referendum on divorce, it's proposed that there will be an amendment to Article 41(3)(3) of the Constitution dealing with the recognition of foreign divorces. In the event that the people give their assent to that change, I would be looking towards updating the recognition of foreign divorces, and that also would look at any negative impact that the withdrawal of the UK from the EU might have. Members will be aware of the uncertainty in some recognitions around the issue of domicile as against residence. But later in the year we'll have an opportunity of updating our laws if we get the approval of the people in that regard.
And just finally, in respect to the area of civil jurisdiction, at present an Irish citizen or any person in Ireland is able to sue a British citizen or company in the Irish courts under the terms of the Brussels regulation. Is there any proposal to have in place reciprocal arrangements to permit that type of process to continue?
It depends on the circumstances. In most cases, you may have to take your action in the UK.
Yeah, this is potentially challenging, and it will depend on the circumstances of each case. But the likelihood will be that the action may well have to be taken in the UK.
Okay. Okay, thanks very much.
Thank you.
Callahan, Deputy Jack Chambers.
Thanks, Chair. Just a question. Deputy O'Callaghan mentioned the reciprocity and the importance of the bilateral agreements which will underpin, I suppose, the general arrangement between Ireland and the UK if it crashes out, as you've said. You mentioned, say, there's a reciprocal arrangement, or the UK have moved on some of these already. What is challenging for your department on matters that they haven't moved upon that you're trying to plan for between now and the end of March? Like what will you be ahead of the curve on that is potentially challenging where they haven't matched their side? Can you give us an update on that?
Well, I think the most pressing and challenging issues are the ones that are specified in the bill, namely the extradition and the matter of immigration / international protection. I have to concede, Caoimhghín, that in a no-deal crash-out scenario, there will be a number of potential problems. The entire regime might be regarded as less than satisfactory. I think the object of the exercise on the part of government is to ensure that our contingencies are in place insofar as they can be. Ultimately, the certainty will perhaps only be evident when agreement is reached between the EU and the UK in respect of the future relationship arrangements. Obviously, while the EU have been the negotiating party, there were certain areas in terms of our relationship with the UK that we needed to discuss, we were discussing, and arising out of these discussions, we have set forward the proposals in the legislation. But there have been and will continue to be instances where we have to fall back on older legislation, less modern and potentially more challenging. But what we are putting forward in the bill is dealing with the urgent and important areas which are likely to prove immediately challenging. And of course, as time passes, we will continue our discussions under the umbrella of the European Union. But I have to say that our objectives and the objectives of the UK are broadly similar, ensuring the protection of our people and ensuring the legal framework that existed between our two countries across a range of issues, both criminal and civil, will continue. Notwithstanding the withdrawal of the UK, or the potential withdrawal of the UK from many of the EU instruments, which have proved very beneficial in terms of our relationship.
Yeah, just an example was given of someone who, say, an Irish citizen who lives and is resident in the north and moves south. Say someone who applied for asylum in the north and they would have a separate process that would be subject to a new arrangement in the UK context. And obviously, we'll have the maintenance of the free travel area. How will the integrity, or what will the bilateral arrangement be in that context between the UK and Ireland? Will there be a homogeneous data sharing process, or what will be the bilateral relationship? And how does the EU feel about a bilateral relationship superseding the integrity of their legal framework under EU treaty law? And how do you deal with that without a deal? And I know obviously a deal is the optimum scenario, but how happy are the EU to allow a series of bilateral arrangements to exist separate from treaty law? As we know, they're very reluctant to allow countries to operate outside of that basis. Or can you give other examples, perhaps on the Eastern Bloc, who have allowed separate legal frameworks to develop secondary or separate to their own treaty framework?
Yeah, well, as members of the European Union, obviously any bilateral arrangements that we will enter into will be within the full knowledge of our EU colleagues. There are certain areas, however, which underline a unique relationship between the UK and Ireland. The fact, for example, that neither of us are in Schengen, and obviously that did result in a situation where bilateral arrangements were optimum. Similarly, the workings of the common travel area and arrangements, where both of us, where both the UK and Ireland joined the European Union with the common travel framework in situ, and that continued. And again, it's important to stress, Caoimhghín, no matter what the nature of the deal is, that the common travel area and arrangements will continue. This is the desire of the UK government, of the Irish government, and indeed the European Union. But I acknowledge that there will be circumstances and instances where we will have to further our bilateral arrangements and enter into agreements with the UK, but this will be done in the context of our remaining members of the European Union and under the umbrella of the European Union.
Just final question was around, Donica asked about just the whole data protection of biometrics, and you mentioned, I think, Mr. Martin, around third-party arrangements. So what will be the data protection process within the UK? Obviously, we'll be subject to EU law and our own Irish legislation. What do you envisage there?
Well, we will obviously, along with 26 EU colleagues, remain firmly wedded to the GDPR provisions. It could well transpire that in the course of the future relationship between the UK and the European Union, that a similar type arrangement is adopted. What we are ensuring for here under this piece of legislation is order to mitigate against any adverse consequences or any gaps that might arise in the sharing of information. And it would be important that we would continue insofar as possible and practicable under the regime that we've currently.
Thank you, Deputy Chambers. Deputy Fitzpatrick, please.
First of all, Minister and officials, listen, thanks very much for coming in today. I really appreciate it. The thing that comes to my mind the whole time is actually the Good Friday Agreement, and since the Good Friday Agreement came in operation, I think the peace that this island has is unprecedented. Like coming from a border of town of Dundalk, I know more than most people the problems that during the Troubles, and I think it's fantastic that this has happened. Minister, my main concern here at the moment is that, I'm just looking through here at the moment, is the Chief Constable in Northern Ireland, George Hamilton. He realises that there is going to be repercussions whether there's a Brexit deal or no Brexit deal is. And what he's asked the UK government for at the moment is that he's asked them for an extra 400 police officers to help man the border area. As you know, said, Minister, the area at the moment, you're talking roughly about 310 miles. And, in Northern Ireland, I think at the moment they've roughly about 6,700 police officers and 79 police stations. What is your plans? What is your plans for the 29th of March? I'm just saying, as I said, they're looking for extra police officers. Now, you just can't click your fingers and maybe get an extra 400 or 500 Garda and put them in the border. What is your plans for the 29th of March to cover the border areas?
Yeah. Well, there is a high-level management team on Garda Síochána that has been working for quite some time. That will deal with any organisational proposals or changes that might evolve in the context of Brexit. They're engaged in ongoing discussions with my department. We meet with the Garda Commissioner on a regular basis. We did so specifically to discuss the issue of Brexit, of contingency planning for Brexit. I have to say, however, that notwithstanding, that we are not engaged in the making of arrangements for what has been described as a hard border. Members will be aware from their discussions with the Garda Commissioner. The Garda Commissioner is solely responsible for the allocation of Garda resources. He has indicated for this year that he intends to recruit a further 600 trainees. The manner in which they are dispersed or allocated stations is one that he from time to time keeps under review. But I want to stress, Caoimhghín, that there is no planning on the part of the Irish Government for the return of a hard border on the island of Ireland. That said, however, and Deputy Fitzpatrick in particular will be familiar with border area and border policing in any frontier, in any area where there is a border of different jurisdictions. There will be a unique need for vigilance in terms of smuggling of either property or people, in terms of organised crime, the allurement that tends to be a border area, and the Garda Commissioner's management team are very much aware of that.
So, Minister, you mentioned in your introduction that the two main areas that you're going to mainly concentrate on, and in fairness, they are high risk, would be extradition and immigration. I've seen it firsthand what actually happens around the border area. I've seen it firsthand, the Gardas pulling traffic off the main motorway onto side roads and such. But my main fear at the moment is, and I think, in fairness, I have to commend the government by reopening Templemore was a fantastic thing to do. I think that was fantastic. But I am a bit concerned there because it's only now over the last number of years since Templemore reopened that the Garda numbers are starting to rise again. And the last thing I want to see is Garda being pulled from all quarters of the country to come up and man the border. People are concerned and people are worried. And as I said, you just can't click a finger. I'm a bit concerned that I know, like you said, there's 600 more trainee Gardaí going through Templemore at the moment, and like the 20 March is fast approaching. I talk to a lot of guards in my area there at the moment, and they're trying to tell me that there's talk now of guards being pulled from every unit and every group around the country. And the people want to know is, should we not have some kind of a strategy plan that we should have, I believe we're opening up customs posts now in the airports and in ports at the moment, and I even seen in the TV last night in Dublin port these extra new huts being set up. But I just think that nobody wants to see a backstop. Nobody wants to see it. Nobody wants to see the border back. And one for all, me living so close to the border and having family and relations and that there in the Northern Ireland, that's the last thing I want to see, because we had a fantastic last 20 years and want that to continue. But there is a lot of fear out there, Minister, that we are going to start going around the country and taking guards in all different units. I'm just in it, and I'm sure yourself and the Garda Commissioner do have regular talking with this at the moment. As I said to you, the Chief Constable in Northern Ireland is in constant talk with the UK. So I'm just going to say, do we have 200, do we have 300, do we have 400 surplus guards that's going to man this border?
Well, the ongoing recruitment to An Garda Síochána will allow the Garda Commissioner to ensure that he has the resources which will be needed to deploy increasing numbers of Gardaí to any part of the country that he deems appropriate in the circumstances. For example, in the Deputy's own area, the Northern Division, in the Northern region, the Garda strength as of the 31st of January this year was 1,406. That's an increase of 9% since the 31st of December 15. What the Garda Commissioner again is doing this year is ensuring, with the recruitment of civilian staff to An Garda Síochána, that he will be in a position to release an extra 500 trained Gardaí from administrative duties to frontline duties. Members will agree that availability and visibility are the hallmark of good policing, and it's important that Gardaí are freed to do the type of work that they're best trained. In the event of there being a crash out, in the event of there being a no deal, and if such a scenario gives rise to additional requirements in border areas, then I have no doubt that further resources can be provided through normal deployment, and the Garda Commissioner and his management team are fully aware of that. And these requirements are kept under ongoing review at all times.
I'm delighted that the PSNI and the Garda have got a fantastic relationship. I'm sure they meet up on a regular basis and that there. And in fairness, Minister, 2 weeks ago, Garda Commissioner Drew Howes came in here and he was talking about that his time in the PSNI, his relationship with MI5 and also his relationship with the Garda and the Síochána. He said it was a great relationship, and I think it's important that we keep that going. When he came in front of the committee there 2 weeks ago, I asked him a question about a local motor in the area, Tom Oliver, and the Garda Commissioner in October 2012 he came in front of the Smiths Tribunal and he gave evidence that he knew the person responsible for the ordering of Tom Oliver, and he said that he wrote the name down and he gave the name to.
Can I ask you, Deputy Fitzpatrick? We know what we're here to address today. It's the legislation that we have. Will you explain the relevance of what you're now addressing to the matter that we have convened this meeting to address?
Well, I want to talk that we do maintain the relationship we have with the PS, and I do want to say I'm commending at the time he was the Deputy Chief Constable. I want to commend him coming down to the Smiths Tribunal and giving the evidence. I basically want to say that the relationship, and it's important that we keep that relationship going. So I would appreciate, Chairperson, you just let me finish off, and then you can ask me the reason I asked the question for, please. I think I'm the first person you interrupted this morning.
No, I want to tell you.
In fairness, other members had a good speak.
Deputy Fitzpatrick, I do not interrupt. The chair never interrupts.
It's the second meeting you interrupted me so far.
No, I conduct the meeting,
I'm sorry,
and I have to be fair.
Well, I feel as though you interrupted me twice. The last time, sorry, excuse me.
No, excuse me.
Okay, I'll let you.
I'm in the chair. Let me assure you. I'm saying to you that we all agree with what is the basic premise of what you're suggesting, that relationships are maintained. You have addressed this matter to the Garda Commissioner only a couple of weeks ago, and I have asked you to explain the relevance of it in your address of it now to the Minister in the context of this particular issue here, which is in relation to the legislation, the miscellaneous provisions legislation before us. So if you wish to proceed, but I'd ask you to ensure that your contribution is in the context of what the meeting is addressing. That's all I have done.
Well, through the chair, I think this is the second time. Sorry, this is the second time I feel as though you've interrupted me. The last time when the Garda Commissioner came in front of the committee, I was asking questions, and in fairness, you made a complaint to me in a private meeting that the comments I made on my local radio station, that you were very disappointed with my comments. So I have nothing to hide at the moment. I just think I have an opportunity here to ask the Minister about the relationship with the PSNI and
which I invite you to proceed.
Which I am doing, which I can't understand why, for some unknown reason, for the second time in a row, that every time I seem to ask about the Tom Oliver situation, you always seem to interrupt me.
Oh.
And sorry, can I finish? Sorry, I'll let you speak. Can I please finish?
Deputy Fitzpatrick, it is not you who will allow the chair to speak.
Well, every time
I'm telling you, it is not an interruption.
Every time I seem to speak, you always seem to be interrupting me, and I think it's very, very unfair. Now, the Minister has an opportunity to either answer the question or not answer the question, the same way that the Garda Commission had an opportunity.
Yeah, but
so
it is
I really appreciate. Sorry, every time I go to speak, are you trying to?
Deputy Fitzpatrick, it is the chair of any committee's responsibility to ensure that the meeting is conducted appropriately and within the context of the issues under address. I am not in any way trying to curtail you. I didn't the first time. I'm not doing it now. I'm asking that you ensure that what you're contributing is in the context of what the meeting is constructed, has been convened to address. That's all I'm asking you to do. Well, so I'm inviting you to proceed.
Well, I'm saying I tried to proceed twice and you've already interrupted me. And I want to put on the record is I feel as though that I'm not getting a fair crack at it from your good self. I feel as though when I did go to ask the Garda Commissioner questions, I think you intervened, and I personally think you intervened was wrong. I'm asking the Minister a few questions today about the relationship with the PSNI and with the Garda of the Síochána, about what's going to happen after the 29th of March. I feel as though there's something seriously wrong here. Why do you keep interrupting me when I'm asking these questions?
I'm not going to repeat my reply to that.
Okay.
I have not interrupted
can I
you.
Please,
That's not what a chair does, Deputy.
Well, then please.
So if you would like to proceed.
Minister, I think we've got a fantastic relationship with the PSNI and the Garda. And as I said to you, I was delighted to see that at the time the Deputy Chief Constable of the PSNI came down to the tribunal and made a contribution. I'm just going to say this, at the time information was passed over to the Garda and the Síochána. I just want to know, Minister, is when the PSNI and the Garda and the Síochána work so close together, that it's very important that whatever information we get, that there is something being done with it. And in fairness, the Garda Commissioner the last day has said to me that basically the information that he got, that he gave to the Irish Government at the time, that he can't really carry it forward because he's in a new role as the Garda Commissioner. But what my main aim today is, I want to make sure that going forward, that whatever information is passed on between the PSNI and the Garda, that it's very important that we act on it. And on behalf of the Tom Oliver family, the government has serious information there at the moment, and the Irish government knows who directed the murder of Tom Oliver. And I'd like to know, Minister, what is going to happen going forward from today. Thank you.
Minister, I invite you to respond to the Deputy. Please.
Well, I can assure Deputy Fitzpatrick and the committee that it is a clear objective of the Irish Government and indeed the Garda Síochána and the PSNI that the very close and positive and constructive relationship that exists between our respective police services will continue post-Brexit and will continue irrespective of the form of Brexit. Indeed, the Garda Commissioner and the Chief Constable of the PSNI, who share responsibility for the cooperation of police services on the island, they have repeatedly emphasise the importance of this relationship. And indeed, there are a number of formal structures involved, like the Joint Agency Task Force, and indeed the cross-border relationship between our respective security services. And I believe it's important that that will continue. And indeed, I'm confident that will continue. In terms of the sharing of information, in terms of the daily contact that I think last year was almost up to 70,000 pieces of information shared. So it's important that will continue. There's one issue, Chair, that I'd like to inform the committee on, which mightn't be widely known. And that is one of the changes that may well be necessary is in respect of the composition or the eligibility for membership of An Garda Síochána. Currently, the Garda Síochána regulations provide that UK nationals are eligible to become members of An Garda Síochána or Garda reservists, but that's on the basis of there being a member of an EU member state. I believe it's important that we continue to ensure that UK nationals continue to be eligible for membership of An Garda Síochána in the event of Brexit proceeding. And that will involve an amendment to current regulations, which will specifically include nationals of the UK. I believe it's important that that be done at an early stage, and it's one of the many changes that we intend bringing forward so as to continue to facilitate those persons from the UK who wish to join An Garda Síochána.
Just to finish off, Minister, listen, I'd like to say thanks very much. I do realise that it is so important that the PSNI and the Garda do work very closely together. As I said here, we have a border there at the moment of 310 miles. For the last 20 years, we had a lot of peace in the area there at the moment, and I think it's no small achievement that the two organisations have been working very, very close together. I just want to put on record, Chairperson, that I am very disappointed that you interrupted me on 2 occasions. You interrupted me when I was talking.
Fitzpatrick, you're very unfair to the Chair. I have a job to do.
Can I please finish?
You may.
That I'm very disappointed that when I was asking the Garda Commissioner about the turmoil of a murder, the Garda Commissioner had no problem giving me a response. When I asked the Minister for a response, the Minister had no problem giving me a response. That the only person I feel that had a problem with me getting 2 responses from the Garda Commissioner and from the Minister is your good self. And I would like to put on the record that I'm very disappointed that every time I seem to speak about the turmoil of a murder, that you interfere. Thank you. Yeah,
well, let me assure you, Deputy Fitzpatrick, the Chair does not interfere nor interrupt. And in the record, you will see that the Chair conducted himself appropriately and as required in the circumstances. Again, I've endeavoured to do that today. So there it is. If we differ, so be it. I'm thanking you, Deputy Fitzpatrick.
The questions I felt as though that I asked the Garda Commission at the time were relevant. The questions I asked the Minister of the day I thought was relevant. I just thought there was no need for yourself to interrupt in 2 occasions.
You keep indicating that, and I'm going to conclude by saying to you that I asked you what questions you were asking of the Garda Commissioners. The record will show you hadn't asked any questions. You had put a statement on the record of the meeting. At that point in time, I asked you to ask a question. This is the record is. And now go on to Senator Neil O'Donnell, please.
Thank you, Minister, and your officials for the presentation this morning. Minister, I just want, given your own personal engagement and interest on the issue, note the significant judgment coming from London and the Supreme Court today in relation to the Pat Finucane case. I'm sure that's a judgment you and your officials will want to study, and your government colleagues, so I don't expect you to comment on that at all, but just to note that it, from the family's perspective. No, I understand. I don't ask for a comment. Yeah, no, I don't expect you to comment on it or respond to it at this stage. I just note it, and indeed its significance. Minister, to go back to an earlier point raised by Deputy O'Leary, and you cited the D'Souza case, one of the big concerns expressed at the recent presentation to this committee by legal and human rights organisations on the impact of Brexit was this notion of citizenship rights versus residency rights, and the concerns about the CTA, as was stated, CTA rights being built on sand. I am glad to hear that you have discussed the issues with the British Home Secretary, but given the live nature of the pursuit of Ahmed D'Souza through the court at the moment, that doesn't necessarily fill us with I suppose from a British government perspective, we have to see legislative action taken that realises fully the Good Friday Agreement. But as Deputy O'Leary also said, and indeed the contributors said the other week, we can also see legislative action being taken in this jurisdiction that fully realises that citizenship rights aspect of the Good Friday Agreement. So, Minister, it's my understanding that on behalf of the committee, the Chair is compiling a report into the contributions and the presentations that we received. I'm sure you'll be facilitated with a copy of that, and I would ask really just to maybe if you could expand on your views on that in terms of what measures can be taken moving forward. I appreciate this is a tight time frame we're in. I appreciate this is uncertain waters, but I think in what has only been sharpened as a result of Brexit indicates that while there's a Brexit or there isn't a Brexit, we do have to get to the point where we're adequately legislating for people's rights in the context and in the spirit of the Good Friday Agreement. And Shin Edge, really, Chair.
Thank you, Senator.
Yeah, thank you. These are issues of great importance, and as I note from reading the transcript of your committee engagements, we're talking really here about fundamental rights. And now I want to acknowledge from my own department, there is, if you like, a primary responsibility on the part of the Department of Foreign Affairs in these issues. I would be happy, of course, to engage further with the Taoiseach. But what I want to say here is it's important to recognise, Caoimhghín, that as provided for under the Good Friday Agreement, the European Convention on Human Rights will remain very much incorporated in law in Northern Ireland. And the UK government has confirmed its continued membership of the Convention. I think if you acknowledge that, along with the importance of the Common Travel Area arrangements, and again, we need to be clear that the Common Travel Area arrangements are maintained in all of the circumstances. We're talking here this morning about the worst-case scenario, a no deal, a crash-out, but it's important to recognise that the full gamut of Common Travel Area practices will continue. This allows Irish citizens, British citizens to access a range of similar rights in each other's jurisdiction. So what I would be keen to assure the committee is that that will be the case, that there are arrangements of a bilateral nature that we need to ensure are in place, hence the importance of the draft legislation that's before us. And on the longer term issue, I would be very happy to engage further with both the Taoiseach and this committee. But these are areas of fundamental rights pertaining to the ongoing relationship north, south, east, west that we need to be mindful of. And I think the exercise that you had was most useful.
Thank you.
Thank you, Senator. Deputy Jim O'Callaghan, you had a further point.
Sorry, I should have mentioned it earlier on. And it concerns a small but vulnerable group of people who are the non-EEA family members of UK citizens. And there's about 5,000 of them, I think, at present in Ireland. And I suppose they're here because of their rights under EU treaty rights. But what is going to happen to them after the UK leaves? Are they still going to be entitled to be resident here? Will they have an entitlement to get a new visa, or what's the situation?
William.
Thanks.
Yeah, the position is that obviously once the UK leave, they are no longer exercising EU treaty rights.
Yeah.
The matter is under consideration at the moment, but in line with what's happening across member states, that the kind of a generous approach, if you like, will be taken. So they certainly, on the 29th of March, they will have status. They won't be illegal or anything like that.
Yes.
And we will have arrangements made in place to probably, if you like, transfer them on to a domestic arrangement. But certainly the intention will be to recognise the fact that they have been resident here, yeah, and that circumstances having changed in terms of their not being exercising EU treaty rights, but nonetheless that they will be facilitated under some kind of a domestic arrangement.
And do you think they will have to apply again for a new visa, or will they just their status be recognised as entitling them to stay and work?
It might be a kind of a combination of recognising current status and then transitioning people into a new arrangement, okay, over a period of time. So it wouldn't be immediate that we would transition people out of one status into another. Okay,
so they won't lose their status or right to be here or right to work?
No, that's...
Okay.
Yeah.
Thanks very much.
All right, Deputy.
Thanks.
Okay. Well, there isn't anything further you would like to add at the conclusion, Minister. Are you okay?
No, I want to thank the committee for their engagement. I again want to point out that these are contingency plans set in place by my government colleagues and myself. I do acknowledge that there are challenges here, and I believe it's important that we continue to engage in order to ensure that we at all times mitigate the adverse consequences of Brexit in all of its forms. But I believe it's important that efforts be made to ensure that, from our perspective, the withdrawal agreement appears to offer, if you like, the best planning in respect of contingencies. Anything less than that, we're into a no-deal situation which, as we have experienced over the last hour or more, is challenging, will be problematic. And I wish to ensure committee members, Minister for Justice, that ultimately our objective is the protection of our people, the safety of our citizens, and that we will do so. We will do so by ensuring that we have a legal framework that will mitigate against negative consequences, of which there will be some.
Thank you, Minister. And on behalf of the committee, my thanks to you and to your officials for your participation here today. With no other further business to address, the joint committee is adjourned until 9 a.m. on next Wednesday, the 6th of March. Caoimhghín.